Hey, Janice.
Hi, Anthony.
Today, let's talk about how to name a professional executor in your DIY will, your do-it-yourself will. So, against all good advice, you've decided to use a DIY will, but you also want to name me as your professional executor. So the question is, can you do both? Will I be an executor on a DIY will? I mean, I don't recommend it, but I have done it. So we'll talk about that today.
So today we will discuss when to call Anthony, when to show Anthony your DIY will, and something called supervised signings.
Right on. All right, let's start off with when to call me. So the question I get is, should I call you before or after I've made the will? There's a couple of ways to think about this. So after is generally better. So that way I can kind of take a look at what you have. Generally what will happen is you'll call me and you'll have your will, I'm going to put quotes around that, your will. So it's pretty much ready, except the executor part is blank because you're trying to figure out who's the best person to be your executor. And I can take a quick look and just see if there's any glaring problems, right? But at the same time, I'm not really here to give you legal advice. If you haven't, just to be blunt, if you haven't paid me to be your estate planning attorney and you're literally approaching me just to be your executor or trustee upon your passing, then not only am I not being compensated for giving a legal opinion, but there's an ethical conundrum there whether or not I really can even.
Right. There's some legalities in there.
Exactly. So yeah, I'll be happy. I have in the past. I'll be happy to point out anything that's just so bad that it would just make the whole thing not functional. But I'm probably not going to opine on things that don't make sense or that are probably going to cause problems for your family later, because that's the kind of stuff that happens when you do things yourself. But yeah, I will point out things that would just make it completely an invalid will. Let's see.
And you would suggest that they do that just after the fact, after it's drafted?
Yeah, I mean, you could contact me before. We've done it that way too. So I'll get a call or an email and we'll do sort of a get to know you, very quick 5-10 minute phone call. And once the client feels comfortable, so okay, I'm gonna go to LegalZoom or a form book and make my quote unquote will, and I'll put your name in. So that's fine too. And again, once you send it back to me, I will let you know if anything is ridiculously wrong with what you've done.
Right.
All right, so then, yes, as I just mentioned, the next step is to make sure you show me your do-it-yourself will. Again, I'm not here to give you legal advice, but I'm just going to make sure that there's nothing that's just going to completely blow up the whole thing. An example of that is recently I was shown a DIY will that didn't have a self-proving affidavit. Now, that's not fatal, but it would make my job a lot harder as your executor later. And I explained that to the client. Look, man, you are giving me a will that's going to make me charge you more or charge your estate more when you're done. Yeah. If you don't want to do that, you need to Google this term or hire an attorney or hire me to fix it for you. And I don't remember how exactly he fixed it, but he ended up fixing it, which again, I'm not really giving legal advice. That's not my role in this relationship, but I want to help. I'm not trying to withhold information.
And you also want to make your job a little bit easier, and like you said, it's going to cost the estate a lot of money to fix it.
Yeah, that's one example, the lack of a self-proving affidavit. Another case that I did was where the client did a DIY will that was so bad, it would have triggered what's called a construction proceeding later. And that means that, after your passing, there's something that's so vague, you need the court to intervene and interpret something. And they have to, reconstruct what the intention of the will maker was. So when I see stuff like that, I'll probably say something like, this is going to be a big problem.
This is going to be that whole thing you said, that doesn't sound very cheap at all. You just said court intervention and
Oh no, that's months and possibly tens of thousands of dollars. Yeah, that's a problem.
Wow. So the money you saved on the DIY will is probably now all gone trying to fix it after the fact.
Yeah, I get that I guess criticism or argument quite a bit. Like, you're anti DIY will because it's against your interest. You're losing the money from preparing, from being the attorney for the will. I'm like, no, I'm not. First of all, we undercharge for making wills. Like those are not profit centers for attorneys like us. Those are just barely break even because you just can't charge that much. We make way more money on messed up wills.
Right. Unfortunately, but
Yeah.
that's the
So I'm
reality.
just trying to help people avoid the headache. So please save that argument for somebody else.
Families, right? Yeah.
All right. So lastly, supervised signings. Okay. So yes, you drafted, quote unquote, drafted your DIY document, but sometimes that's the source of the problem, like the wording. But more often than not, one of the sources of the problems is that it was not signed correctly, that the execution ceremony was not handled technically correctly.
Right.
That causes lots of expensive problems later. So, how do you resolve that? I have colleagues who are, licensed attorneys who sort of have broken out that portion of their service and are willing to to conduct an attorney supervised will signing for your DIY will for a very reasonable fee, sometimes as low as I think $200. Right?
Okay.
You get an attorney and even witnesses, professional witnesses, to make sure that your again air quotes document is signed properly.
Okay.
Again, these attorneys will not review, again, just for the same reasons I outlined before. They're not being paid for that. But at least you'll know that signing technicalities will have been done correctly, according to New York law.
Okay. That's very interesting.
Oh, one other thing, another benefit you get from an attorney supervised signing is that there are certain presumptions, legal assumptions that you get if a will signing has been supervised by an attorney. And if it's a self-supervised signing, I think there's for example, a 30 or 90-day waiting period you have to undergo during probate if it's not supervised by an attorney. So basically you save a couple months just by having an attorney supervise.
Interesting. So save some time, save some money, do it right.
Yep.
Okay.
All right. So we're getting a couple of these now. Again, people during these strange times are deciding to do their estate plans. But yeah, I understand not everybody wants to spend money on an attorney. I get it. So
absolutely.
Yeah, there's no reason if you're interested in naming me as your professional executor in your DIY estate plan, I'm game. But just understand the pros and cons and how we'll go about it. I think that's it for today.
Absolutely. Well, listen, if you want to dig in a little bit deeper here, you can read Anthony's books, How to Hire an Executor, and the Solo Ager Estate Plan, both available on Amazon.
Very good. Thank you, Janice. Thanks, everyone, for listening. We'll talk again soon.
We will talk soon.
Bye now.